I will tend to go. I will tend to go beyond gene patents, I expect, because I sort of, as you'll see, I see gene patents as just a subset of the larger inquiry into patents on research that leads to drugs, genetics-based research typically, but not always, that leads to drugs and other therapies. So if I use examples outside the genetics area, you'll understand the reason why. In addition, I have to apologize. The slides are probably not as detailed as they should be. I'm going to be saying a lot that's not on the slides, primarily because I just didn't have the time to put everything on the slides. So I guess another way of saying the same thing is pay attention to me and not the slides necessarily, anyway. There's been, as no doubt everyone here knows, a lot of controversy about patents on genes that are implicated in various disease processes. And it seems to me that there are at least two sets of issues. Oh, this is the mouse here. Okay. Raised by these patents. And they're somewhat distinct, although, as I'll point out as I go through my talk, not entirely so. Some of the issues surround impediments that patents on genes, among other types of upstream research, might pose to further research, i.e. downstream research. And in the particular context of genes, various commentators have been concerned that broad product patents on genes that code for certain types of proteins, such as receptors, that might have multiple different biological functions, might pose impediments to future research, and I'll talk about the reasons why. And as I mentioned, in this respect, the concern about gene patents is really part of the more general concern about patenting research tools, particularly research tools that are what I'll call broadly enabling. In other words, they lead in many different directions rather than towards a single commercial end product. Another set of concerns has involved not access by scientists, but access by patients, by end users, not with respect to the therapies that emerge from genetics research, but with respect to some of the stuff, some of the diagnostic tests in particular that are emerging right now and have emerged already. So there has been quite a bit of concern about diagnostic tests based upon gene patents that are priced above marginal cost, well above marginal cost, and what that means for access, primarily by patients, but as I'll talk about, the patient research issues get intermingled because some of this clinical testing obviously involves patients, but is also meant to be research as well. So before I get into these two sets of issues, I do want to step back for a second and give you my sense, and I apologize if this is something that is a sort of old hat to all of you, but give you my sense of how gene patents fit into the patent system more generally and why it is that we've arrived at this situation where, I was talking to Alan Buchanan earlier about this, where there is a sort of a group of people, sort of the policy elite, as it were, who really, I mean, I think it's fair to say for them that gene patents are sort of an issue that's sort of long past. They're clearly there. There are thousands of them out there. You know, they're just not going away. Whereas in the popular consciousness, there seems to be a feeling that there's something really quite anomalous about these gene patents. And I think part of the reason for this is the way that gene patents emerged. When they first emerged in the late 1980s and early 1990s, no one actually paid a lot of attention to these patents. I mean, it was really quite remarkable how unremarked upon they were. And I think this is the case for two reasons. From the patent lawyer's perspective, which I guess is the policy elite to some extent perspective, gene patents are really nothing new in the sense that patent law for the last century at least has allowed patents on what are called purified and isolated versions of products that occur in nature. So the argument that was made by patent lawyers was that cDNAs, which is what was being patented, as opposed to genes as they occur within us, are really just like all those other things that were patented before that were purified versions of what occurred in nature. So cDNAs had been extracted from the chromosomal context and are free of non-coding material. So that's why patent lawyers never raised an eyebrow, and why, as far as I can tell, there's actually never been a single legal case that discusses why cDNAs should be patentable subject matter. So when people ask me, well, what's the case I should look at? Well, there hasn't been a case because for patent lawyers, this was sort of old hat. Well, what about the public? That's probably the more interesting question. Why wasn't the public sort of more aware of these gene patents when they first emerged? Well, even from the public standpoint, these early gene patents were not unusual. And the reason is because they covered what were really end product drug therapies. For example, one of the most prominent early patents on genes was Amgen's patent on a cDNA encoding erythropoietin, which is a specific therapy meant to enhance red blood cells for people, meant to produce red blood cells in the systems of people who are deficient in that production. So it was an end product drug therapy, and we in the U.S. system have long accepted that end product drug therapies are the subject of patent rights, can be priced at higher than marginal cost, and to the extent that these the higher than marginal cost consequence of patents causes a problem, we tend to want to take care of it on the demand side, i.e. through systems of insurance that make drugs more accessible. Obviously, there are real problems and gaps in those systems of insurance, but that's how we tend to, in the United States, look at dealing with problems of access caused by patents, on end products. All right, so in contrast, current gene patents are not on end product therapies, and so they raise distinct problems, questions, concerns from the early gene patents, and that's where the debate is now, obviously. So let me first talk about the access issues faced by scientists, and here the access issues, as I've suggested, are really part of the larger question of access to research tools more generally, and they're at least threefold. First and most obviously, we might be concerned that scientists, particularly scientists at nonprofit institutions, may not be able to pay the super competitive prices necessary for access to research tools, including gene patents. Now, as people have pointed out, there are probably informal regimes of what's known as price discrimination that operate in favor of academic scientists. In other words, companies don't really tend to sue academic scientists so much. But there is some leakage in those informal regimes of just not suing academic researchers. DuPont, for example, has in various contexts had, and this is again outside the gene patent arena, but it has had patents on some pretty fundamental research tools, knockout mice and oncomice, and at various points it's threatened to place some pretty onerous restrictions on academic researchers, and the threats have been beaten back to some extent by the NIH, but it's not as if these threats don't exist. So there is a concern about sort of onerous proprietary restrictions being put on even academic scientists who may not be able to pay for such restrictions. Second, if the gene patent or the research tool patent more generally is a broadly enabling patent that might be implicated in lots of different diseases, then we might want to have lots of different groups doing research on that broadly enabling patent. And the worry here is that the owner of that patent, that broad upstream patent, may not be inclined to license to lots of different people who are potential either research competitors in the academic context or commercial competitors. And there's a history of broad upstream patents in other industries, such as the aircraft industry, the automobile industry, or the radio industry, posing at least temporary problems for the cumulative innovation in those industries. And then finally, and this is something that I know that Wes Cohen, who's in the audience, has paid a lot of attention to, there might be concern that there is not simply just one initial broad patent, such as a gene patent in some cases, but other patents that also have to be licensed in order to do work on the gene. The patent system allows what's known as blocking patents. In other words, it allows people to claim rights in the same piece of research territory. So the mere fact that one person has a broad right doesn't preclude others from having some rights in that research territory that might have to be licensed subsequently by other researchers. So the term that's sometimes used to describe this potential problem, at least, is the anti-commons problem or a patent thicket problem. All right, then there's access by patients, and this is an issue that I know that other panel members are going to talk about, so I'll just talk about it a little more in a more abbreviated fashion. Here the access problem is somewhat distinct, although not altogether distinct. The clinical researchers who are using diagnostic tests want to be able to either make these tests themselves or license them for something not too much greater than marginal cost. But in a lot of these cases, there are patents involved, and so the tests are much more expensive than they should be, or they would be in a competitive market. So this raises two problems. It raises problems for researchers who want to do research, particularly in universities, because they argue anyway, and there are people at University of Pennsylvania in particular who've been very vocal in this regard, argue that they just can't possibly pay those super competitive prices for access to the patented diagnostic tests. So that's one problem, and then the other problem is that even though they sometimes do try to charge patients for these diagnostic tests, insurance companies don't necessarily cover the use of these tests. My take on this question, admittedly not entirely well thought out, since I've only been thinking about these questions for the last 6 months or so, is that it seems to me here we're talking about a situation where a large component of what's going on is really the access problem caused by patents, similar to the access problem caused by patents on end product therapies, in that you've got something that's marketed directly to patients, and insurance companies should be paying for this sort of thing. They're not, and there's some sort of problem there, but it's not entirely clear that this is a problem for the patent system as opposed to a problem in terms on the insurance end of things. Now, as I've said, there's overlap between the traditional patient access, which is covered by insurance companies typically, and research access, but it seems to me that if university labs are doing diagnostic testing and charging patients for such testing, there's some problem on the insurance side if the insurance companies can't pay for the super competitive prices charged by the diagnostic test owners. All right. So what are some of the policy solutions to the extent there is a problem of access either by patients or by researchers? What are some of the policy approaches that we can use? Well, I've talked a little bit already about how I think that with respect to diagnostic tests and patented inventions that are marketed directly to end users, I think that's an issue for the insurance side. But what about the more typical context that I've focused more on, which is research access in the preclinical setting? Well, here I think the policy solutions are multifold, and there are two approaches about which I've written in the past, and I have some confidence in these approaches, although they have problems of their own. First, we might be look to patent scope and narrow patent scope, particularly on broadly enabling research tools, including some types of gene patents. Not all gene patents are broadly enabling research tools, and actually perhaps not even most. But to the extent they are, we may look to keeping patent scope on those tools narrow. And that will facilitate licensing and bargains and between downstream and upstream researchers. The problem with the way that the legal system is set up is that it's difficult to make the scope of patents on upstream research narrow without correspondingly making the scope of patents on more downstream research, like the actual drugs, also narrow. And that's a difficulty that we have to figure out how to deal with in our patent system, because it seems to me ideally what we'd like is narrow scope upstream but not narrow scope downstream when you actually have a pharmaceutical of some sort. It seems to me at the downstream stage, a broader scope is probably necessary for innovation. What would a patent of narrow scope on a gene look like? Well, under current patent law, the entity that files the first product patent on a gene is generally entitled to claim a property interest in all uses of that gene. So one way of narrowing scope might be to limit the patentee to the uses it had actually found, or lest that make patents too weak, we could perhaps include uses within the same category of disease that the patentee was investigating. So that's one option. Another option that I have written more recently about, along with Rebecca Eisenberg at the University of Michigan, would be some type of reform of the Bigel Act. For those of you who are not familiar with the Bigel Act, this is legislation that gives universities the right to seek patents on their publicly funded research. Now, Bigel doesn't rely on the traditional rationale for patents, i.e. that patents are necessary to motivate the research in the first place, because public funding presumably provides that motivation. The rationale instead is that if universities patent and then license their patents exclusively to private companies will have an incentive to commercialize the research, because they'll have a monopoly protection in that area of research. Now, when Bigel was first passed, I think that, and for a period of time after it was passed, universities tended to be relatively careful in how they applied for patents under Bigel. They tended not to patent the most upstream research, or at least if they patented it, they tended to give non-exclusive licenses. And the reasons for this are basically that the norms of open science continue to exert influence. Bigel was passed in 1980, and it seems to me that through at least the first decade or so, the universities tended to be relatively cautious in their patenting practices. So the norms are fairly sticky, to use the term sometimes employed by norm scholars. But I think unfortunately, these relatively sticky norms are getting unstuck. And the reason it seems to me that this is the case is that the scientists who tend to adhere to these norms, the research or bench scientists, often for the good self-serving reason that they don't want lots of stuff patented, because they'll have to license those patented materials from other scientists. They don't make the decisions with respect to patenting or with respect to any claims of proprietary rights. Typically, those decisions are vested in university technology transfer offices, in the administrators in university technology transfer offices. And the technology transfer offices have a real incentive to go out and seek as many patents or other types of proprietary rights as possible, because they're judged by how much money they bring in. They don't have to pay any of the transaction costs of licensing other people's proprietary tools, because those are paid by the researchers through their grants, through their NIH grants. So there's a disconnect between who gets the benefits and who bears the costs of these proprietary tools. And not surprisingly, those who get the benefits tend to be big fans of them. Those who bear the costs are a little more cautious. And the entities that bear the costs are the scientists and ultimately NIH. Unfortunately, thus far, or in recent years, we've seen the tech transfer offices becoming quite aggressive in claiming quite basic, broadly enabling research platforms. One platform that I just read about a few weeks ago involves a cell signaling pathway known as the NFKB cell signaling pathway that's apparently implicated in a huge number of different diseases ranging from cancer to osteoporosis to arthritis. Harvard, MIT, and the Whitehead Institute jointly own a patent that just issued actually in 2002. And they're now threatening to sue about 50 different companies, 50 different companies, who have developed or are working on drug products that use this particular pathway. Now, obviously, these particular companies didn't need a license to Harvard and MIT's and Whitehead's patent in order to be motivated to develop their product. But now the universities are coming in and saying, you know, you need to pay. They're seeking their rents now because these products are already on the market and making lots of money, and they're asking for a cut. So it seems to me that's a pretty bold exercise in pure rent seeking. As matters currently stand, NIH has really very little power to control the patenting and licensing activities of university grantees. There are very significant administrative hurdles it would have to overcome if it wanted to, for example, condition funding on an agreement not to seek proprietary rights. And in point of fact, as a consequence, NIH has actually used this power only once and in a very narrow context. Instead, NIH has tended to rely on the bully pulpit, urging university scientists that certain types of patenting or proprietary rights would be contrary to traditional norms of science. And these scientists had some influence over the university administrators who made the final decisions. But as I've suggested, it's kind of a tenuous situation because the administrators really don't feel bound by these norms and certainly don't face the transaction costs of licensing tools themselves. So the trend appears to be towards norm slippage and increased proprietary claims. NIH, of course, by contrast, does bear some of the costs of these increased proprietary claims because in its grants, through its grants, scientists have to pay all the transaction costs of licensing all this upstream research from other universities. So the bottom line is I think there may be reason to reform Bigel so as to give agencies such as NIH a little more discretion to control patenting and other assertions of proprietary rights. All right. Then, and this is the slide I never quite finished, but other directions for the future. I think that there are a lot of really interesting ideas to think about in terms of sort of balancing the public domain and proprietary rights in biopharmaceutical development as it becomes, biopharmaceutical development becomes more of an information science. One very straightforward idea could, or has already actually, people have already begun to focus on the idea that the bioinformatics software that is developed and is used in biopharmaceutical development could be distributed under what's known as an open source model in which proprietary rights, where the software is exchanged freely and nobody can claim proprietary rights. In fact, a group of bioinformatics researchers petitioned NIH to require that all federally funded bioinformatics software use an open source model. NIH unfortunately said that it felt constrained by Bigel and wasn't sure it could implement that requirement. So that's an interesting implication of Bigel even in the software context. Now, there's also, I've been thinking about the question of whether open source models could apply to biopharmaceutical development even outside the software context. There's a problem because research does tend to get very expensive as you move further downstream, and open source models don't allow claims of proprietary rights at any point At least in the software context, that's the way it's been working. But that's clearly not going to work in biopharma. At some point, you really do need proprietary rights. So I've been thinking about how we might be able to structure open source models of exchange that would allow the claim of proprietary rights at some point down the R&D path. A third issue, which is more doctrinal, that I think really needs to be considered is that as genetics research does become more informatics-based, we really have to think about the way, and this gets into sort of technical doctrinal patent law, but we really have to think very hard about the way the primary court that deals with patents, the Federal Circuit, thinks about these patents. It doesn't seem to have any sense that that information is the key to genes, essentially. And so it set up a very high bar, or a very low bar to getting gene patents, a ridiculously low bar in my estimation. And so I think that that's a real concern as well. We have to think about what to do about this very low non-obviousness bar that's been set up. And then finally, and I don't want to get too much into the territory of what is the final panel, but as some of you probably know, now patents are being sought for genes and proteins not in their biological form, but in silico. And so what we're really talking about is mere data, patents sought on mere data. And there are real questions as to the extent to which patents should be granted on mere data that I think are really important to think about. So with that, I'll close. And, oh, wonderful, you just put up the sign too. I never finish on time. Thank you very much.
Well, thank you, Arti. I know I certainly have a lot of questions. I could fill the whole question session with questions for Arti. I am very pleased to introduce our next speaker, Sharon Terry. I have read about Sharon and Patrick Terry's activities for the last few years, and so I was very pleased to meet them this morning. Sharon Terry is president of the Genetic Alliance and the founding executive director of PXE International, a lay advocacy group for the genetic condition pseudoxanthoma elasticum, which is known as by the acronym PXE, which is what I will call it from here on out. Following the diagnosis of their 2 children with PXE in 1995, Sharon and her husband Patrick have built and founded a dynamic organization that fosters ethical research and policy, as well as support for members and the public. In 5 years, PXE International has established and directed a 19 research lab consortium, 52 offices worldwide, a blood and tissue bank, and database of thousands of affected individuals, and many important services for affected patients and their families. A very, very impressive resume indeed. Ms. Terry has co-authored a number of papers, including 2 papers on the discovery of the PXE gene published in Nature Genetics, a very prestigious journal for those of you who are not familiar with it. In June 2000, she is also named as a co-inventor of the PXE gene and has filed a patent application on this invention. Ms. Terry also serves as an ethical, legal, and social implications research advisor to the federal government, is a member of other governmental agencies, a governmental advisory committee on genetics, and is a member of the board of directors of the Biotechnology Institute and is president of the Coalition of Heritable Disorders on Connective Tissue. Sharon?
Thank you. I should use the same disclaimer that my husband did yesterday, and that this is certainly a arena that I don't possess the credentials for in the least, except that I've worked a lot in this area in a very practical way. I have a master's in religious studies, so I can do didactic exegesis on various passages in the New Testament, but not anything in this arena. I'm going to focus the patenting debate in the consumer issues arena. I am the president of the Genetic Alliance, which is a coalition of 300 lay advocacy groups involved in genetics, so genetic disease organizations. And as such, I work with those 300 organizations and about 300 others that are resource organizations to work at and look at these issues very practically. So I see them in terms of affordability and access issues, and I'm really probably going to pose a lot more questions than answers in a sense, or models particularly. We come to this with these sentiments. We need a treatment. How do we get them? to do what we want, and how do we figure out what they need so that we get what we want. So a very practical kind of orientation. When we look at this, we have to think about whose agenda are we looking at. Are we looking at a consumer agenda? Or are we looking at a researcher/industry agenda? Most of the time that I'm having this discussion or debate, it's in more ethics and policy sorts of arenas, not so much in a law arena. And this has been a really exciting 2 days for Pat and me to hear a more nuanced discussion and less emotional and kind of territorial one. However, I think even yesterday there were certain points where I would have asked, what is your agenda for putting forth your considerations? And even with regard to groups like Affymetrix, who in fact are friends of ours, I would say, what's your agenda? Why are you against patents versus somebody else who is in favor of patents? So I think we just should keep the agenda in mind when we're looking at trying to have a reasonable discussion in this regard. I think we have to recognize the limitations of us and them, and I think we have to stop thinking about us and them. And so my first slide, where I was being very pointed about saying, we need this, they are doing that, I think we have to erase that kind of thinking and start to think about what are we going to do together about solving these problems. And that recognizing the agenda is agenda and not moral law. So not trying to come to these things by saying, morally, I believe that there should be no patents, when in fact having no patents benefits me in another way, and isn't really a reflection about whether or not it's a truth, an absolute truth, but instead a reflection about what are my needs. And just recognizing that in the discussion as well, I think helps the discussion. I think the challenges, and I'm going to shift here a little from what seems to be not directly related to patenting, but I think has a lot to do about access and affordability in terms of treatments and even diagnostics. Some of the challenges that we face, and I'm going to say we, all of us, is that there's a limited pool of willing participants for research. And sometimes Pat and I are criticized in these kinds of discussions with the caveat that, well, you come from the rare disease research community, and that's really different than the common disease research community. I'm going to say that it's not different. I'm going to say that you can talk to, for example, Genentech before Herceptin was discovered, was finally licensed, about how many women were participating in their trials. They would have said to you there's a limited pool of participants, even in something like breast cancer. And so I think overall we're looking at limitations in terms of how much consumers are willing to participate in research, as well as when we start to move into the pharmacogenetics arena, all common diseases are going to become rare diseases. All of us are going to be segmented into various populations, and those populations are going to have different characteristics one from another, and that's going to make all of us rare in some way or another. And that's going to be a major consideration as we move forward. Inadequate funding across the board. I think most scientists will tell you there's inadequate funding for the things they need to do. I think as a nation we can say there's inadequate funding for the kinds of research we want done today, especially when we're faced with a diagnosis of colon cancer in our father this afternoon, or our sister with breast cancer. There's inadequate funding. We all need to see that increased. And a competitive, fragmented, and unfocused research environment. And I will say that our experience, and it has been borne out even in common diseases, has shown that because of the competition in research, and we are well aware that there needs to be competition in research, that's how people are going to be motivated to get it done. But because of that competition, there's been a real fragmentation of the research environment and a lack of focus for the end product. Now, there's not been a lack of focus for, well, I'm working on this particular thing and I need to get it from A to Z finished. There has been a lack of focus, though, for saying, I want to have a treatment for this. Often that kind of research gets derailed on the path because of other pathways that look more lucrative, look more prestigious, lead to better kinds of publications in terms of the science. And so I think we just want to think about how do we focus science in this country, how do we focus research, and whether or not it's being served in the best manner it can be. I think the resulting difficulties from that are redundant small collections, whether, again, you're talking about breast cancer or something like PXE or xeroderma pigmentosum or a dozen or hundreds of other small diseases. There's small collections all over the US and the world, and they're redundant, and that makes the research very difficult. There's poor confidentiality protections. And again, this seems tangential to the patent issue, but I think it really gives the platform for this discussion in a more broad sense. Confidentiality protections are very varied across the spectrum in terms of using human biological samples. And those confidentiality protections are, in fact, sometimes retrospectively not enough, and sometimes being used for things further down the research pipeline that they shouldn't be because of the protections that they were or were not given in the beginning. a variable informed decision-making process. This is a nuanced kind of thing in the ethics circles, in the ELSI, ethical, legal, and social implication circles. Very often people talk about informed consent. And we propose that to talk about informed consent presumes that someone should consent. And instead, we're really looking at an informed decision-making process. And that process is not often given the kind of resources that it needs as well. And inaccurate disease characterization is a result of these redundant small collections. The literature itself propagates misinformation and real difficulty in terms of understanding where the disease is going or what its characteristics are, and limited reporting back to participants. I think all the way through this, my mantra is going to be, if consumers are more involved in the process, all the way through, we're going to see better solutions, quicker solutions, and more practical solutions. So a solution, just one, is to use a commodity to create a community, to leverage funding, and to coordinate the research. And that's my experience, is to use a commodity to do these things. And I would propose that you could do this in a number of ways. You heard yesterday from Pat somewhat about the PXE International patent and organization. I'm going to talk a little more about that in a slightly different way. I would also say that, for example, and this is just an example and perhaps, I think a question we should ask is when we have something like Myriad Genetics having the patent on BRCA1 and 2, and therefore collecting all the data on it, they're creating a commodity in a way, and maybe in some ways it's better to have that information centrally banked, with some other considerations certainly taken into consideration there. Already isolated by diagnosis, participants feel mined for their biological samples, and they sense little regard for the whole system, for the familial and social and cultural kinds of things, contexts that they come from. And I think that that's an important part in the policy considerations when we're talking about research and patents and diagnostics, et cetera. The commodity that we built was a lay advocacy-based biobank. I'm going to extend this to include also lay advocacy controlled and initiated clinical trials, because I think that there could be a place for lay advocacy groups in both of those things. Biobanks are being used by a number of groups. PXE International was probably the first lay group to entirely control a biobank, but now there are a number of groups who we have mentored, at least 10 who have launched their own biobanks. And in fact, the Genetic Alliance is looking at creating a very large resource, which would be a resource for whomever, whatever of the lay advocacy groups wanted to bank, so that research could not only be done in a siloed manner like it is now, but also across disease, which I think is going to be a whole lot more informative to us. With lay advocacy groups involved in the mix, we're going to keep the focus on the result, which is a treatment. And again, I'm not going to say cure, because I think for most things we're not going to see cures, but treatments for diseases, and not for all the other kinds of products in between. We recognize those products are important, and they in fact are the pathway. If I'm going to wait for the University of Hawaii, who are co-discoverers of the gene with me, to discover a treatment, that's not going to happen. But if I'm going to be able to license this gene patent to other organizations, including industry, we may see things happen more quickly. So in this regard, we're going to see individuals recruited in an atmosphere of trust. What we have created in PXE International is really a community. So the individuals who come to us really trust what we're doing with their biological materials and know that we're safeguarding them in a number of ways. Pat showed yesterday the kind of firewall between the identifiers and the researchers, and that's really critical in the community that we've created, both that we report back to them, that they understand the process that their samples are being used for, and that they're very eager to be part of that process because they feel very connected and they also feel very protected. That we engage in culturally sensitive, comprehensive, informed decision-making process. Again, none of the people who have donated, for example, to the PXE International Blood and Tissue Bank have been coerced in any way that I can imagine. I contend that you're almost always coerced when you have a disease, that you don't really have a free choice in the sense of somebody else who walks in off the street to decide whether or not to contribute to a biobank for a particular endeavor. But I think as much as possible we can make that procedure or that process comfortable for them, and so that in the end the decision is theirs. And I think that can be modified or used for a great number of diseases. And that identifiers are encoded in a centralized database so that we have control of that information. Researchers never have access to identifying information. That is really a relief for researchers. It may seem that we're switching the scales and we're being paternalistic and patronizing now. I think instead what we're finding is researchers have been very happy with that situation because it takes away a whole lot of IRB issues. The IRB is on our end. Our blood and tissue bank has IRB approval, and there's certainly all the high bars. And in fact, we raised a bunch of them and said, you really should ask us to go over this one as well. But as far as researchers, they then have samples with no identifiers. They can even ask, can you go back and ask such and such and such and such to these patients I can do that easily because I have a relationship with these people. They don't have to go through an IRB process that says, no, you cannot recontact. No, you can't use the samples now for X, Y, and Z because you only consented for A, B, and C. So we can take care of all those things behind our firewall. This method of management, I think, assures compliance with all the oversight and regulatory guidelines. And again, I think we even raise the bar higher. We sit on every single national advisory committee in terms of human protection research right now. And we have been able to say, here's the protections we need, and there are even more. We've been able to apply those to the biobanks that we've helped to found. Pat talked briefly about working with indigenous peoples, and even in third world nations now we're helping some of those countries establish this kind of system. Provide access to a comprehensive archive of samples. There are too many fragmented collections, as I said before, and so now we have archived things in one place in a really comprehensive manner with the kind of revisiting that one constantly needs to give this sort of bank. Maintains the integrity of various world and local communities' collections and research projects. As you know, there's really very sensitive feelings about certain areas and about biopiratism and helicopter science and all the kinds of exploitation sorts of things that happen. And what we're advocating for is really doing this, again, in a community context in a way that the community understands what's happening and feels part of the project. Keeps the research coordinated and focused on affected individuals and their families, and I've already reiterated that. So the results for consumers, so that's the results for the research. For the consumers is integrated ethical, legal, and social issue kinds of protections, a new paradigm for dynamic partnerships. I think consumers have long felt that the whole field of health research, medicine, is something that has been paternalistic and patriarchal and not something that they've been able to feel a part of. And I think with direct-to-consumer marketing, it's going to be blown open, and we're going to have to pay attention to how the relationship of the patient changes in the health arena. And I think if we can, on the research end of it, start to be more aware of that as we go, then when we get to the product end and we're selling things and patents and licenses are important, then they'll be more in sync with who we are as a society, and the policy will be more accurate. Accelerated research and affordable, accessible diagnostics and treatments. I think what we're going to see, too, is that we can keep the process in tune with the end product as we go, we're going to be able to focus better and have the treatments be more accessible. There have been some stories and some issues around, for example, Canavan. People probably have heard of a disease called Canavan, which is a rare disease. Had a very difficult time with the fact that researchers at Miami Children's Hospital patented the gene for Canavan after using the blood products of their children and other tissue products. We as a group and even as a Genetic Alliance have looked very carefully at this issue because this particular case has been brought up a great deal. When individuals contribute to a biobank, by law, they have no right to the patent. The inventorship comes from being part of the discovery, and that's how I am an inventor on the patent, not because we gave blood and tissue, but because I in fact worked in a wet lab and worked on the various parts of the discovery process. The sort of the next piece, so inventorship's one issue. The next piece is whether or not it's ethical or fair to have a license that costs money. And these people with Canavan have complained that the license has added $12.50 to the test. The whole test for Canavan's disease costs $60. And for us, the question is not more, what does it cost and did somebody layer this on? More the question for us is, what has it done to access? And we have not been able to find anyone who said they have not had access to that test because it costs $60. We also point out that right now the test for PXE, which we own, when we buy it, because we have to pay someone to do the sequencing, is $3,000. So what kinds of economy of scale are we building, and how are they relevant or relative to one another, I think is another really critical issue when we start to cry about these things. And it's really important that we cry about the right things in the process. So the empowered, informed consumer are individuals and groups who are full partners, and I think that that will ensure that the benefits outweigh the risks and they will accelerate research to treatments. It's really lovely that we have all this great research going on. It's also very interesting to us when, and in fact, I was glad Arti brought up the subject of tech transfer offices and universities, in fact, have been the most difficult in some instances for us to work with. Industry has been easy. And usually we're having this discussion, for example, at the American Society of Human Genetics meeting in 2 weeks, and it's academics who are saying to us, oh, industry's horrible, they are patenting like mad. Well, universities are patenting like mad, and university tech transfer office officials are really, really after the buck and squeezing everything they can out of whatever they can. So it's really interesting also, again, not to look at it as a moral stance. Academia is pure and it's ivory tower and industry's dirty and tainted. I think we're really looking at some of the same issues there, and we should recognize them while we're going forward. Potential scenarios might be, is that the patent holder, you can be a patent holder if you meet the requirements of inventorship. It's not going to be really common that a lay group follows the model that we've set up here, but I think that there are other things. You can do equivalent rights by negotiation. Somebody's asked us, so what if all the patents are already out there and you want to do something? I think there's ways that you can negotiate things, and we're already working with a couple of groups who are in fact in that sort of end user negotiations. Alternative forms of benefit sharing. People have also asked us, so what about the patients in your group? Do they get money back if you make some money on the PXE patent? The patients in our community has decided what we want is a treatment for PXE. We don't want money. We don't even want a discounted test in terms of finances. If we can get a treatment for PXE, that's our goal. The benefit sharing will be that, yes, we're all on the same course. We decided together we want the benefit of a treatment for PXE in this instance. And then the patent holder driving the public welfare. There may be ways that we can see patent holders just make ethical decisions, make decisions about moving something from research to treatment in a way that benefits the public and is important. Policy implications, I would say, is to see past the agendas. When we're setting policy, and again, even in our discussions with policy people, I think that we have to forget about Democratic and Republican agendas. I think we have to forget about industry versus patient agendas, academia. I think we have to forget about those agendas and look more deeply at the real agenda. It's not ethicists, and it's real interesting to us that ethicists claim to take up our banner. They come to us, consumer groups, and say, we're in there fighting for you. Well, we've begun to see in some instances, and again, certainly not overall, but that ethicists have made the ethics a god. And the ethics aren't moving us toward the end product, which is treatment for the people that we seek treatment for. And so they're another hurdle for us. Instead of them taking care of our cause and walking side by side with us, they have instead said, we're the experts, we're going to negotiate this for you, and never should there be this, or only should there be this. And we're saying, this is a really nuanced gray area, and we need you to work with us and walk with us so that we can all get there at the same time and not make ethics a god. That's really difficult. The science is not the god. There have been so many times, and I'll use again the example of PXE, that they've found something terribly interesting. There were 5 candidate genes in the region, and 2 were unknown. And they said, well, let's go characterize those 2 unknown genes. That's really exciting. Well, there was no linkage with people who have PXE for those 2 genes. That's not important to me. It's important scientifically, and maybe there's something really wonderful there, and they may even have blown their careers. But for me, the important thing is getting to the treatment. So I think as long as we're clear about those agendas, where they overlap, and then when we're working on those agendas together, will make a real difference. I also think that sometimes science, if you just let the science dictate something, it will go in a direction that's wonderful, exciting, and groundbreaking, but may not deliver where it needs to deliver. I'm certainly also not against basic science. In fact, Pat and I have funded a bunch of basic science that's led to treatments for glaucoma, things not related at all to our kids' disease, and we're really happy about that. But I think if we at least consider what we need to consider to go where we need to go, it will make our decision-making much easier. And not earmarked diseases either. I think policy should not be about earmarked diseases, and we see that a lot. Advocacy groups go to the Hill and say, you need to give this much money to my disease. And I am totally against earmarking. Our daughter's testified twice before Congress, and neither time has she said earmark money for PXE, not for connective tissue diseases, not for membrane transport protein diseases. She said all research needs to go forward. Please make sure you consider that when you're appropriating money for all the various budgets. It's really important to us that earmark disease also not be the policy driver. Body count politics is really popular in the US, and for some reasons that needs to be done. We need to pay attention to AIDS when AIDS is an important issue. We need to pay attention to cancer when it's an important issue. But as soon as we start looking at all these things on a cellular and molecular level, there's going to be a lot of interchange between diseases, and working on all of these diseases will make a difference. Some alternative regimes one might propose are to revise the PTO guidelines, and we did see that happen in 2001 with the utility agreements changes. Legal reforms, genetic exceptionalism is a whole other area I'm not going to talk about right now, but that's an area that we should think about, whether or not we're creating a kind of genetic exceptionalism in the reforms we might consider. Political and regulatory exemptions, and the Rivers bill, for example, with exemptions for research status may be something to consider. Litigation is a route that someone could use and talk about compulsory licensing. Active infringement, France is engaged, at least France and several European countries, in active infringement is a option. Statutory revisions, we could, for example, decide that we're going to limit some patents to 10 years instead of 20 years. And eminent domain, we could take public action and take a license or a patenting over. This is Elizabeth and Ian Terry. I have informed consent, and I pay them royalties for this photograph, use of this photograph. They're very savvy, as you can imagine. And I think that winning for them and for millions of Americans and for the industry, whether it's academia, the biotech industry, pharma, whatever, requires that all of us partner together today. Thanks very much.
Thank you, Sharon, for a very interesting talk. Our last speaker is Bob Cook-Deegen, sort of a newcomer to the Duke community. He is the director of the Center for Genome Ethics, Law, and Policy here at Duke University. Until July 2002, he directed the Robert Wood Johnson Foundation Health Policy Fellowship Program at the Institute of Medicine at the National Academy of Sciences. He's also a Robert Wood Johnson Health Policy Investigator at the Kennedy Institute of Ethics, Georgetown University, where he is completing a primer on how national policy decisions are made about health research. Dr. Cook-Deegen has taught a seminar for the Stanford and Washington program since early 1997, and with 2 Stanford students recently directed a world survey of genomics research. And Bob?
Thank you, Karen. Can you hear me? I can't tell. Is it coming out? Okay, thanks. I'm going to use the lavalier mark. Those of you who were at the talk last night realized that I almost blew out everybody's eardrum because I kept getting close and then backing away from the microphone. So I'm just going to use this one. I thought I was kind of taking a guess about what people were going to have talked about yesterday and what Arti was going to talk about today. So I see as my task trying to begin to converge a little bit. So the very back end of this talk is going to be actually a list of options for various actors, things that have been floated as policy options. But in the way to get there, I'm going to go through some data, and then I'm going to go through kind of a conceptual framework, and then I'll end up with those policy options. And I guess I pushed this. This actually was inspired, has absolutely nothing to do with the talk, but I was fiddling with PowerPoint yesterday when Lila talked about the prodigal adolescent biotech industry related to genomics, and I realized that we had to do a gender correction. So this is a gender-corrected version of the Return of the Prodigal Daughter. The question for you is whether Lauren, of course, as our father, is she blessing Leela Fazey, or is she blessing Barbara Caulfield as they've wandered off, squandered their inheritance, or are coming back to ask for forgiveness? And this is also to remind me to notice that the Digital Millennium Copyright Act, this is still copyrighted. Digital Millennium means the copyright extends for the death of the author plus a millennium. So Rembrandt still has the copyright here. I'm going to be referring to 2 data sources in addition to the work that's beginning to happen here at Duke. There are 2 groups of people that I need to recognize for having contributed to some of the analysis here. One is a group that is working on the DNA patent database. You'll see some data from this. The database is actually an open, web-available search engine for looking at patents that have 1 or more claims that are based on DNA or RNA. I'll show some data from that, but this is a large team. And actually, last night when I logged onto my email, we got notification from NIH that we've got a couple of grants that are starting up to begin to use this database as a tool for getting at some of the issues we're talking about here, the licensing practices in academic institutions, how they handle DNA-based patents, how do they license them, what do they do with them. And the World Survey of Funding for Genomics Research, this was done originally with Amber Johnson and Carmi Chan, 2 undergraduates. And now actually 3 more undergraduates have been brought into the fold because the database has gotten pretty big, and we're going to be doing an update. I'll show some data from that survey. But basically what we did is we took a look at who funds genomics research from all over the world, starting with nonprofit and government sources of funding. But then we realized that a lot of stuff was going on in the private sector, so we actually began to keep track of it, and it turned into an incredibly big list of 400-some companies that are doing work in genomics that either they call themselves or other people call them a genomics company, and we've been trying to keep track of that since sometime in the spring of the year 2000, and we're now going through the process of updating them. And one of the things we're trying to update is how many patents each one of those companies owns, and the private institutions and like universities and nonprofit research institutions. So this is one of the results for the year 2000, which is the most recent year for which we have data now. This is how much money is being spent on genomics. So this is just, the next few slides are just going to be kind of general background on what's going on in the world. If you look at it, there are about $1.6 billion that were spent by places like the National Institutes of Health, Department of Energy, NSF, the Howard Hughes Medical Institute in the United States, and then their foreign equivalents. So these are mainly these are all government and nonprofit on the left edge. That's the 1.6 billion, and that's what most people think of as the Human Genome Project. That was the original idea of the Human Genome Project, right? It was going to be a public domain. It was kind of the interstate highway system for human genetics. It was going to be a publicly funded effort to build all the scaffolding for doing high-tech whiz-bang genetics for the next several decades. But it turns out that starting in 1993, private investment began to happen. And this has happened over and over again in history, and it has happened in the life sciences in particular over the last 2 decades. A big public investment in science begins to produce things that look valuable, socially valuable, medically valuable, and commercially valuable, and it begins to induce private investment. So that by the year 2000, in fact, it looks like the private investment was, if you add it up, the middle blue bar is publicly traded companies. At this time, there are 72 or 73 of those publicly traded firms. And because they're publicly traded, they have to report how much they've spent on R&D every year to the Securities and Exchange Commission. You can go get those data. That's what you're looking at here. We added up all those numbers from those companies. That's what they spend on R&D. Now, not all of that's genomics. Some of these companies do lots of things. Genomics is only a subsection of that. But it gives you a ballpark. And then we also surveyed large pharmaceutical and established biotech companies, things like Amgen, Genentech, Pfizer, Lilly, Merck, and asked them how much are they spending on genomics. Now, very few of them gave us any data, but a few of them did, so we made some guesses about how much overall, and it looks like 3 to 5% of their R&D budget was devoted to genomics, which leads to a figure of in the order of $1 billion. So if you add it up, you got 2/3 private sector, 1/3 public sector in genomics, and that's probably about right. This slide shows what we've been talking about for the last few days. This is how many U.S. patents, these are only U.S. issued patents. This is the holdings of the DNA patent database. A couple things that I want to point out about this. If you add up the number of patents under the curve there, up through January of this year, it's 30,000 patents that have been issued. Now, again, this is patents, U.S. patents, that have one or more claims that match a search term. So what we have is a search algorithm that's about 25 steps, and we're twiddling with it. By the time we're done, it's going to have probably 40 or 50 steps, where you go through and you go into the whole database of U.S. patents, and you start pulling patents out, and then you start throwing them back away, and you end up with a set that are intended to capture those patents that focus one way or another on DNA or RNA. Now, only about 20% of those, 15 to 20% of those, are gene patents. So most of them are things like, I've got a method for finding X, or I've got a regulatory sequence for blah. That's not a gene, but it is a piece of DNA, or it's a method based on DNA or RNA.
Bob, is that per year, not cumulative?
This is, each of the dots is per year, and then the integral underneath is the 30,000. So, that point one. Point two, it's very interesting. We all think that DNA patenting started with Coe and Boyer, right? Wrong. Very interesting. I discovered as we actually had to hand read all of the patents from 1970. We started, actually there aren't any in 1970. 71 through 1980, which is December 1980 is when the Coe and Boyer patent came out. We hand read all of those patents and coded them. And we found about 300 patents that fell into our data set, and we read all of those. And it turns out about 80 of them actually they do say something about DNA and RNA. And in fact, there is a patented DNA sequence method from 1973. Now, I'd never heard of it. I don't think anybody ever used it. But there's a patent for it. So you discover these things when you actually do empirical research. But the thing is, it was already happening before Cohen-Boyer. It was already beginning to happen. A lot of those 1971 to 1980 patents are actually held by universities. So Bidole was already beginning to happen before Bidole Act was passed. That is, universities were beginning to patent things that they discovered with federally funded research before the policy kind of caught up to them. So in a way, the Bidole statute really codified what was already beginning to go on. This has actually been documented by very careful empirical research by a variety of people, including Wes. So this is not a surprise, but it's interesting. We can corroborate with the figures. Finally, what's going on at the tail end there? You see this exponential rise beginning in the early 1990s, and then you see a downdraft in 1999 and the year 2000. What's going on there? Well, remember, we did have a policy shift that began in 1999 at the U.S. Patent Office, where they raised the bar for utility. Now, we can argue, Arti and I will no doubt have a discussion about the obviousness and the non-obviousness and the novelty criterion. The third big criterion is utility. And what the Patent Office did is it pushed that bar higher, so it got harder to get a gene patent. So we think that might explain the notch. Oh, and they also asked, they pushed up the bar in another axis, which is how much do you have to explain about your invention when you write about it in the patent application. That's called written description. Nobody ever paid any attention to that until a court case, UC versus Lilly. But suddenly it became very important, and that bar also went up. You had to be much more careful that you had described what you had invented in the patent application. So those two factors, those changes in policy might explain that downdraft, but it went back up the next year. But it looks like, and while I've been here, folks up in Washington have been busily loading patents into the database. So in fact, if you try to find it today, it won't be there because the servers are being, they're getting fed their new patents. It looks like it may be down this year from last year. So we may be beginning to reach some sort of steady state in the DNA patenting game. Who holds those patents? Now this is through December of 1999. So this is out of about 20,000 patents. Who owns them? Well, pertinent to what Barbara Caulfield was saying yesterday, this is kind of interesting pattern. Look at numbers 1 and 2. U.S. government and University of California system. And then number 3 is Insight, one of the firms that you heard talked about. Number 4 is Chiron. That was kind of a first-generation biotech firm. In fact, most of those patents are not Chiron patents. Those are Cetus patents. This was a company that they gobbled up. And they got their intellectual property when they gobbled them up several years ago. And then you get to number 5, and it's GlaxoSmithKline. So you have to get out to number 5 before you get the first big pharmaceutical firm. Look at that. That's very interesting. 5 different kinds of organizations are the big 5 patent holders. They have very disparate interests and perspectives on the science, on the patenting, and how they're going to handle these patents. Government, private academia, public university. Insight was one of these genomic startup firms. Chiron, established biotech firm, and a major pharmaceutical firm. And you keep going down the list. You will eventually hit Hopkins and Harvard. These are private universities that are somewhat different from the public universities. So you got a lot of different stakeholders that own this intellectual property. I will come back to this in a later slide. But if you add it all up, who actually owns this intellectual property? Now, this is a subset of all of the patents that I showed you on this graph. This only covers the years 1980 to 1993. That included originally about 1,300 patents. We read them all by hand, and then we coded them. And we coded them in several respects. Who owns them? What kind of owner? Was government involved in funding the research that led to the invention? Things like that. And then we also had codes for what was claimed in the patents. So is it a full-length gene? Is it a partial gene? Is it human? Is it non-human? We did that all by hand, and then we've done some data runs on it. But the thing is, we've only got those data for the 1,000-plus patents that we did 1980 to 1993. It takes a lot of time and effort to read these patents and code them. So we don't have any data since 1993. We're right now beginning kind of a biopsy. We're going to take like 2 months worth of patents from 2001 or 2002 and do the same kind of thing. So I don't know if this reflects what's happened since 1993. This is only that subset of those patents. But when you look at it, it's a really bizarre pattern. What you see is that companies own 52% of that. I mean, that's the usual pattern, right? Is that companies own most of these patents because they're in the business of doing things with with intellectual property. The really bizarre thing about this set of patents is the other side of the equation. Government, 6%. Those are those NIH mainly patents that have grown out of the NIH intramural research program. Nonprofit research institutes that like Scripps, Salk, Whitehead, private universities, public universities. So if you add up all the things that we think of as the academic research sector, they own more than a third and almost half of this intellectual property. That's a bizarre pattern. You won't find that in very many other parts of the innovation system. It matters, and I'll come back to that again. And finally, this is the slide that when I show this to foreign audiences, they go ballistic. The U.S. now again, this is only the subset through 99. In fact, no, this is only the subset from 80 to 93. So this may or may not represent what's been happening since then. But of that 1,000+ patents that we've read and hand-coded, the U.S. owns 80% of them. Japan is number 2, and almost all of the other players are European, rich European countries. So when I show this slide in Mexico or at WHO, at the World Health Organization in Geneva, or I have people from Africa or Thailand or whatever in the audience, they see this as a foreign policy issue because we own the intellectual property for the human genome, and we will be extracting dollars and rubles and yen and every other kind of currency that we can extract. And they don't see the policy issues in the same framework that we do. France, you'll notice here, for example, owns 2.4% of these patents. I don't find it terribly surprising that the BRCA patent is handled somewhat differently and perceived somewhat differently in France than it is here in light of these overall data. They don't have as big a stake in protecting strong intellectual property rights on genes as the US does. So now I'm going to do a little background stuff that I think I'm trying to just summarize and say obvious things that have come out of the discussions for the last 2 days. So I'm going to go through these slides pretty quickly. These are Rosenberg patents, okay? These are the good guys. These are the things where the patent is actually doing some work in the system. It's inducing investment in valuable good things, right? And these are also, for the most part, first-generation gene patents on end products. These are therapeutic proteins that are saving lives that wouldn't have happened probably if there weren't an incentive for private investment in the R&D that led to their discovery and, more importantly, their clinical testing and deployment into the health system. So you have human insulin. You have the clot-dissolving enzymes like tissue plasminogen activator and growth factors like erythropoietin and Neupogen and all the things that are used. These are all in clinical practice. The patents behind these, like there are 4 patents for erythropoietin, they're incredibly valuable for Amgen. All of these have been litigated. These are cases where people went to court and fought about the intellectual property rights. They usually spent between $10 million and $30 million litigating it, and at the end of the day, somebody won and somebody lost. The ones who won get all the money. It's a winner-take-all system, basically. So this is kind of close to the classic pharmaceutical development framework, right? You patent a molecule. It happens this time to be DNA, and you patent the DNA because the DNA is the easiest way to produce the therapeutic protein. And so that's the framework, and it's very natural that the court system kind of took the pharmaceutical framework and applied it to genes. And when we say these are success stories, what do we mean? We mean 3 different things that are not necessarily always in alignment, but in these cases they are. They're clinically useful. That is, they do something that people are willing to pay a lot of money for. So it's commercially successful, and it really mattered. I mean, these were out there at the cutting edge of science and doing useful things. So this is a wonderful success story, right? This is the patent system when it's doing what it's supposed to do. Then we've got some patents, lots of patents about techniques. The first one that everybody knows about is Cohen-Boyer. It was non-exclusively licensed, openly prosecuted, and probably if challenged would have fallen apart. But at the end of the day, it's now expired, so we can actually talk about it. It generated $250 million that was split up between Stanford and the University of California. At the end of the day, what the Cohen-Boyer patent basically did was it got a lot of attention to recombinant DNA, and it generated some research dollars for those two university systems. So they got to tax the innovation system, and they got to spend the money on research at their institutions. That's kind of my perspective on it. Polymerase chain reaction was discovered at CETUS, licensed to, when CETUS died, they were licensed to other companies, Hoffman LaRoche and PerkinElmer. But the technique itself became very widespread. There was some fighting over how those intellectual property rights were going to be disposed. Initially, Hoffman LaRoche wanted to reach through. That is, they wanted to say, if you use this technique, we get a piece of the action on anything you discover with it. There was a blowback. The academic community wouldn't buy that, so Hoffman LaRoche backed down. This is your classic bargaining in the public over licensing of a very important seminal technology. Four-color fluorescence automated sequencing. Very valuable patent for set of patents for applied biosystems. This is the big profit center for the company, what is now Aplera. Their profit margins have always been higher than any other part of what was PerkinElmer. So this has been very successful then. It's very classic, right? You get the patent, you develop an instrument, because it takes a lot of money to develop an instrument. You put it out there, people buy it, and you get paid higher amounts of money than you would have if you didn't have a patent. Multiplex sequencing is another method that was patented, licensed to a particular company, and it's one of the ways of doing high-throughput sequencing. But fortunately, it's not the only one. Lots of patents on microarray techniques. We talked about that yesterday. There's a pioneer patent on gene transfer that covers humans and other mammals. This actually grew out of the very first cooperative research and development agreement that NIH ever did that was licensed to a company in my neighborhood in Maryland. So there are lots of success stories in the techniques, right? These things are patented. They're actually widely used. They may cost a little bit more, but the system seems to have adjusted. But I did want to point out there are techniques that are just as patentable, just as important, just as widely disseminated, and have not added to costs on the right side over here. So these are the Boyle technologies. These are the public domain technologies, right? Fred Sanger got his Nobel Prize for sequencing insulin, the protein, and then he got a second Nobel Prize for discovering a method for DNA sequencing. And in fact, if you look at a single seminal figure behind the Human Genome Project, all the vectors point towards Fred Sanger. It was his philosophy of doing science that drove it. You know what? Was it novel? Was it non-obvious? Boy, was it non-obvious. Was it useful? Boy, was it useful. Could it have been patented? Absolutely. Did he patent it? No. Why? If you ask Fred Sanger that question, he says, well, why would I? It just wasn't part of the ethos. So it was not patented. Wally Gilbert, who was the CEO of a biotech firm for a while. It's not like he's against patenting, but he didn't patent Maxim and Gilbert sequencing. And it's not because it wasn't patentable. Because remember, I just said there was a 1973 patent on DNA sequencing methods. Both of those techniques spread like wildfire in the mid-1970s and became incredibly important to the rapid development of lots of science in molecular biology. Monoclonal antibodies were also not patented, but the method was not patented, but lots of individual monoclonal antibodies have been patented. So what we've got here is the classic story of penicillin. This was a discovery made in the UK, not patented, but then in the US, there were lots of patents on penicillin manufacturing. The US companies made all the money off of manufacturing penicillin. Same thing in monoclonals. The discovery was made in the UK. Lots of patents on specific monoclonal antibodies, and mostly US companies made all the money off of the technology. So it's actually caused a major set of debates in the UK, and the same kinds of policies that we've done in the United States, they've done in the UK in spades, because they want their scientists to start patenting much more aggressively, because they've lost out on penicillin and monoclonal antibodies now. A very similar story in diagnostics. On the left edge are all sorts of discoveries that are used in the diagnostic context mainly that are patented. I'm not going to go through each of the stories, but I also wanted to point out there is a Boyle story to this subtext also, in that there are lots of genes that are not patented. The counterpart to BRCA1 and 2, for example, is P53. It's a very important cancer-related gene, but as far as I can tell, unless I've missed it, there is no dominant patent on the discovery of the gene itself. What we've got is patents on uses and mutations and variants, but no central dominant patent for P53. So we've got all sorts of different patterns of patenting going on. And this, I'll say just a word about the SNP because nobody else has talked about this. SNPs are these single variations between individuals where in your base pairs there's just one difference between you and somebody else. That's called a single nucleotide polymorphism because there's only one, at one base pair there's a difference between two individuals. Well, it turns out those are really important markers. There are millions of them that you can conceive of discovering. And big pharmaceutical firms were very concerned because these are your quintessential research tools. You need to have a lot of them for them to be useful. You need to put them out on a map. You need to know where they're located. And large pharmaceutical firms saw them as very important for things like understanding pharmacogenomics and how people respond. It's basically just a way of painting the chromosome so that you can follow inheritance and so that you can compare two individuals and how they vary in their responses and then go back to the genes and figure out what's going on at the genetic level. So they're markers. And the concern was if those are patented, and there were small biotech companies that were beginning to say, what we're going to do is we're going to find SNPs and we're going to sell access to those SNPs as a business model. The big pharma firms got upset about that, got worried that in fact they could do that and they might be blocked from being able to use these tools. So what they did was something incredibly sophisticated. A consortium of firms, biotech and pharma firms, got together and said, we'll pay for the science, and we're going to file patent applications. So they did. They filed patent applications as they discovered these SNPs. But then what they did was they would characterize the SNPs and they would find out where they were on the chromosomes and whether they were useful. And then they would abandon the patent. So if anybody ever challenged the patent, they would have had the first filing date. But then when they abandoned it, nobody could do anything about it. So what's that? What did they do at the end of the day? What they were trying to do was make sure that these ended up in the public domain. And it was a very sophisticated strategy for ensuring that these things landed in the public domain. So the SNP consortium did that. There was some talk yesterday, and I wanted to hit this. There was some talk yesterday that the alternative to the patent system is trade secrets, and that is true. And that is true even in genomics to a certain extent. The thing I want to point out, however, is that biomedical research is different in a fundamental respect from most other areas of technological development, in that there is a huge, well-funded public domain research effort that goes on regardless of what happens in the private sector. So it is not true that trade secrecy is a viable strategy for certain kinds of research. Sequencing is one of those areas where it is not the case that if you try to keep a sequence secret, it will remain secret. It will not for very long. So I just want to be clear on this. We do not have a patent regime in genomics right now. What we have is a trade secret regime that is coupled to a patent regime. So what companies do is they do not publish their sequences as they discover them. They keep them secret, put them into the patent system as in the form of patent applications, but those don't become public until the patent application is published. As of last November, that will be after 18 months if they're filing for international rights. But they have a window of secrecy. That is the window of time when sequence information is actually valuable to the world. So we do not have a pure patent system or a pure trade secret system. What we have is a trade secret system that gives way to a patent system. And the companies are actually in this wonderful position of not having to give up either one, because they get trade secrecy when the information is most valuable, and then they get the patent rights if they succeed in getting a patent through the patent office. In one respect, therefore, the patent system, because of the time value of information in this domain, the the patent system is failing in one of the things that it's supposed to do, which is to make information available, publicly available, and open. That's what patent means, is open. It's not doing that at the time when the information is actually valuable to the research community. That may or may not be a fatal flaw. It's just an observation that that's actually what's happening. And the other thing about this is that, in fact, genes are a fixed set. And some of the concern about genes, and this is unusual, this is different from classic pharmaceuticals. When you patent Viagra, if you look at the Viagra patent that Pfizer put in, the structure of the claims, I tried to add it up once, because what you do when you do a small molecule patent is you patent a kind of a core molecule, and then you have these things that are called R groups. And you specify what those groups are in the molecule. So it turns out that I think the Viagra patent would cover about 1 million molecular entities. That is, you could conceive that there would be about 1 million molecules that would fit. But it's a really complicated molecule, so that's actually fairly narrow. But it's something that somebody had to make from scratch, to synthesize from scratch, right? So when you make your claims about that molecule, you've kind of got a specified set of things, and somebody would have to invent something completely new. And that's how the courts have kind of interpreted this. When you're in the gene business, what you're doing is you're discovering something that was in nature. And it is different. It's a fixed set of genes that are going to be of importance in human health applications. And it makes it harder to work around. And it also means that you are discovering something and you're claiming something that's a variant of or a purified version of something that exists in nature. Some of the concern among scientists stems from this fixed set problem. The early debate about DNA patenting was concerned that Human Genome Sciences, Insight, and the other private biotech companies would actually lock up all of the set of genes, and you wouldn't be able to do anything without getting permission from one of the companies. Why? Because there are only so many genes in the genome, and everybody's going to be wanting to use them. You cannot work around it quite as easily. So I just wanted, this is going to be a quick kind of semi-taxonomy, and you'll notice that some patents appear in multiple categories, so there's no clean taxonomy that I've been able to do. But this is just to stress one really obvious point. The main thing that's going on, the main work that the patent system is doing, is inducing investment that pulls things through the development process. The patents are not inducing investment for discovery, because we don't really need the patent incentive for that in the health environment, but it is allowing somebody to protect their investment through a very expensive development process, either an instrument or a clinical testing regime. And those are examples of things that kind of fit that classic framework. These are a list of patents that, in my judgment, and that's all it is, would have happened anyway, even without the patent incentive, where I actually am not sure that the patent system is actually doing any work other than increasing the cost and changing who it is that wins. So I could be challenged on any of these cases, but that's kind of my personal interpretation. So we have some patents that are clearly doing a lot of work, and other patents where it's not clear that they are actually doing any work other than increasing the cost of doing the research. One thing we can say for sure is that two things are happening out of patents. One is that startup firms, as you heard several stories of yesterday, it's being used as kind of the chips that you put on the table to induce investors to give you money so that you can do what you want to do. And universities have discovered it's a source of income. In fact, in the year 2000, the surveys, the institutions surveyed by the Association of University Technology Managers brought in about $1.1 billion. And then the private research institutes got another $200 million. So $1.3 billion of revenue stream brought in by patent licensing, about 70 to 80% of which is based on life sciences. So most of this is coming out of NIH and NSF and DOE funding. This has already been talked about by Arti. I just wanted to make one point about it. The whole idea of the Bigel Act was to create an incentive for, the problem that the Bigel Act was trying to do was solve the problem that you discover something that might be useful, but then a university is not in the business of manufacturing things or making things move into practice. And small businesses have the same problem. So the idea was to create an incentive to create intellectual property that could be licensed out and induce linkages to the business sector. So the very purpose of it was to induce academic institutions and nonprofits and small businesses to work with people that would try to make money off of their inventions. So let me be clear on this. A lot of the criticism of Bigel is actually that it's accomplishing what it's supposed to do. It's corrupting the universities. Well, you know what? This is U.S. policy that was specific. If that's your framework, you're in the pure science camp, the policy was intended to corrupt universities and get them to work with business. Is this a great country or what? I mean, that's what it was supposed to do. So, given that that's happened, and here I'm going to turn to specific things that specific groups could think about doing as we think about policy options for fixing the various problems that have been discussed. I actually think the biggest problem in Bigel is not any of the things we've talked about, but the fact that nobody knows what's going on. The reason nobody knows what's going on is because nobody has to collect any data. And just one little vignette, when you make a discovery under a federal grant or contract, you're supposed to report to the government that you've done that, and then you're supposed to put in the patent that you file at the patent office that you've done that. Well, as we read through these 1,000 patents that were issued 1980 to 1993, almost all of them were done under Bigel. And we discovered about 150 of them that looked really, to our eyes, like they'd been developed with federal funding, but didn't say anything about the federal government in the content of the patent. It's actually illegal. And it turns out when the GAO has gone after research institutions, they've discovered it's very, very common that the Bigel rights are not acknowledged in the patents. And it's like 20% of the time. So how can that happen? Well, it's because there's not much transparency built into the system. It's very hard for university technology offices to know how their licensees use it. It's very hard for NIH to keep track of what's going on at the universities and the research institutions. Bigel didn't think about this. It's a big problem because we're making lots of policies and we are flying blind. We got to fix that. There is the possibility. Barbara Caulfield yesterday talked about a research exemption. And you could have a general research exemption that's recognized in the statute, which is how they do it in Europe. But one thing that's been talked about is actually not worry about twiddling with the Patent Act as a whole, but in fact just make sure that those inventions that are discovered using federal funds would be exempt from patent infringement if the research that's being done is being done by another federal grantee or contractor. So this is not an overall research exemption. This would be a research exemption under Bigel that would basically say anytime you have an invention made with federal funds, part of the licensing would say you get to use it for free if you have an NIH grant or an NSF grant or something like that. So it's a subset that is aimed at a targeted type of institution. As you heard, there's a diagnostic use exemption to address some of the issues that have come up most starkly with BRCA. This was part of the Rivers bill that was introduced last session. And Arti and Becky Eisenberg have argued for two possible changes to the Bigel statute. I just wanted to clarify there are two things that the government could do to reform, to twiddle at the margins of Bigel. One is to make it easier to decide at the front end where you're building a research program to say, in this case, we really don't think patenting is a good idea. So when would that happen? Well, it happened when NCI decided to go ahead and do gene sequencing on a lot of genes. They actually went to the Commerce Department. NIH has to go to the Commerce Department and say, can we have permission to keep the patent rights instead of giving them to universities? In this case, the Commerce Department said yes, because what you're trying to do is create sequence in the public domain. So they got a declaration of exceptional circumstances from the Commerce Department. They then mounted a research program, and the contracts basically said, if you take our money, you dump the data, you give the data to us, and we're going to dump it into the public domain. We can choose whether to patent it or not. That we meaning the government, NCI. And of course, NCI is not going to patent it. So it's, in fact, a no patent policy. So it's very hard for NIH to do that now, or NSF or whatever. It would not be hard to make it a little bit easier for them, although you'd have to define the criteria. At the back end, once discoveries have already been made and licensed and stuff like that, The government also has a right to march in under 4 criteria. One of those is if it affects the public health. That march-in authority has never been used. One of the reasons it's never been used is because it's almost intractable. It's almost a no-win situation for NIH or NSF or anybody who wants to march in, so they've never done it. And one little idea that a couple of us had a few years ago was, let's handle sequence data differently from other data because its time value is different from most scientific information. So, and it turns out that as of last year, when you do a patent application to the office, the patent office, that includes sequence information, you send it separately to the patent office. It would be really easy as a logistical matter to make those data available earlier. The companies don't like this idea, so we had actually initially proposed that it only be true of federal grantees and contractors, so you would do it under Bigel. Then very quickly, I'm going to just really zip through the last few options. One is, I'm just going to jump through this. The one that I wanted to focus on out of that universities could do is actually the patent pools issue. I want to take you back to that original slide of who owns those patents. Number 2 was the University of California. If you add them all up, universities have a lot of the intellectual property here. And if there were ever a place where a patent pool might work, my guess is it might start with some combination of NIH and the universities deciding that in the long run we're all going to be better off if we just throw all this stuff into a pool that we all trust, and we can reduce the transaction costs in the long run by creating patent pools. I don't know what that's going to look like, but I would like to see some more serious dialogue about that, and I would think the place to start that dialogue would be among the universities or NIH, which is the other possible source of leadership in this. The other thing NIH can do, and is actually already doing, is giving guidance on what do you do about research tools. Because they give out the money, they are at a position to be able to influence a lot of the players in the game. And we've already talked about the exceptional circumstances and march-in criteria. It would be very useful if NIH were given more flexibility in that. And then companies themselves can do things. Even without the government doing anything, you've seen Merck march in and say, we're going to fund public domain science. The SNP consortium formed to move things into the public domain. So there are lots of things that the companies themselves could do without having to come to Washington. The last one is the one that I want to stress, which is some guidance on licensing practices. This is an area where I just think it's ripe. People are out there that everybody is complaining. The companies are complaining, the universities are complaining, the scientists are complaining, the National Academy of Sciences is complaining. Guys, let's stop whining and let's actually start developing some guidelines so that people know what's going on. This links back to the transparency. We haven't created informational markets where anybody knows very well what's going on. We should fix that. We should begin to fix that incrementally at the margins and begin to share information. Thank you.
Well, thank you. Well, if I can kick off the question and discussion session, I should add that Bob is actually an expert on the Human Genome Project and has written a book on that topic. If I could fix this. So, Bob, I was wondering, do you think, in view of the Human Genome Project and some of the other sequencing efforts, do you think that some of the issues that you all expressed the most concern about so-called gene patents, do you think that they are being mooted by the Human Genome Project? As these coding sequences go into the public domain, it arguably will not be possible to get patents on the underlying sequences themselves.
Yes and no, because the thing that's important to remember is the time value of this stuff and the history of this. Insight in human genome sciences, because NIH decided not to do gene sequencing, that is cDNA sequencing, as part of the Genome Project in the early years, it left the field open for companies. That's why they got their capital initially. That's why Wally Steinberg founded Human Genome Sciences. He realized we could actually make money because NIH isn't doing this, so we don't have to compete with the public domain. The Merck project didn't start for 3 or 4 years. So there's a 3 or 4 year window when Insight in Human Genome Sciences and other small genome startups had a free rein. They were filing patent applications, and those were the pre-95 rules. So those are probably, some of them are probably still submarining. So
they had a lot of years to find a lot of genes and make claims on them. And we actually don't know, because it's not public, until it comes up in the form of an issued patent, or they choose to announce what's happening with that particular patent. So we don't know, actually, I don't think. In theory, the stuff that began in the public domain after that would preclude patenting, but what we don't know is what the time sequence is of when the data became public relative to when the filings were made. And we won't know that because it's secret.
So within 20 years or so, this may be in the
Yes.
dustbins of history?
Yeah, 20 years, of course we will, because the patent term would have expired regardless.
Yes?
Bob, I'd like to focus back on one of your last slides where you suggested among policy options that companies might follow the development of practice guidelines for licensing. And the reason I ask this is that I've talked to some technology transfer people at a couple of different universities who expressed ethical concerns about what was happening to the test kits or other things that were developed by academic researchers, what happened when they got out there in the world. And they were looking for ways of placing some constraints on the uses of these products through licensing, by adding conditions to licensing that are not the sort that we ordinarily think of, that is, that were in some way to reduce ethical risk. What sort of practice guidelines are you talking about for licensing? What do you think you need?
Well, that isn't what I was thinking of, although it could certainly be used for that purpose.
What were you thinking?
I was, well, you know, it's actually really, what are the royalty rates? You know what? If you talk to people trying to get, to make a deal, you need 4 genes, right? You're trying to, you're a company and you're trying to develop a product, and you need to work with 4 receptor genes or something like that. And you go to NIH and you get a certain, how much money do you have to put down on the barrelhead and how much royalty stream. Those can vary by a factor of 10. And if the holdout is the person who charges the most, that can actually obstruct the whole line of research. And part of the reason, I think, is because the universities only have this very loose, informal network of sharing what their rates are and how they're doing it. Now, they do kind of have a sense of it, but you can't have that kind of variation in a system where the informational markets are working. It wouldn't happen. Yeah. So that's what I was thinking of. But certainly you could link it to the sort of thing you're talking about.
Do you think the process of trying to formulate practice guidelines might itself produce information
Yes.
that would solve the transparency problem,
Yes.
reduce it, and then the guidelines wouldn't actually do what's doing the work necessarily?
That's right. And the other sort of thing I was thinking of is there's no reason that these patent holders couldn't right now, like Hopkins has, say, if you're going to use our invention, academic and nonprofit research institutions get to use this invention for free. So they build a research exemption into their license.
I think that's actually, I mean, very problematic, trying to come up with any kind of research exemption, because academic institutions don't just do academic research. Obviously, and this is the problem that came up in the context of the stem cell agreement that NIH negotiated with WRF over the WRF stem cell patent, which basically says, well, okay, so other academic institutions can use these stem cell lines without, without infringing WRF's patent, or they have a license to do so, but not once it becomes commercial. And then the question is, that's a sort of bonanza for lawyers: what's commercial and what's not. I mean, and I think that's part of the larger problem with practice guidelines in this area is that you do have, and a lot of people have talked about this. You do have such disparate players. I mean, it really is, and I think that's what was one of the most interesting things about one of Bob's slides was how disparate the players are in this industry. And I think it'll be interesting to see what happens kind of in the industry context, whether we will see some more integration such that we don't have genomics companies and pharma companies, so that we have like biopharm companies all around. And I think in that case, there may be more likelihood of some sort of patent pool situation occurring. But when you have not only universities creating their own messes, but also disparate players in the private sector, I think there's less likelihood of some sort of collective action taking place in that context.
Just to dilate on that problem, because I'll now speak from the other side of my mouth on this. One of the problems with the research exemption is, if you think about it, and I'll be very specific, think about what Duke does in this area. as an academic research institution. Now, it has federal grants and contracts, so it would be eligible for all these exemptions if we framed them in that if that was how you framed the exemption. You take what Duke does and what all the other health systems in this area do and subtract that. So you get a certain set of activities that Duke does that nobody else in this area does because it's really expensive or it's really high tech. And those things militate to academic research centers. They tend to be cutting edge technologies, very expensive things. Those are services that are provided by an academic research center, and they're profit centers for that academic research center. And if they were under the research exemption, you're killing some pretty big markets that are actually really important for pulling these technologies into being, because that's the money, that's the opening market. So there are some dangers with the research exemption. I still think it's something that we could work out if we were smart enough.
Following up on, given the clear difficulties in delineating in law research exemption that'll work and not just create a lot of income for attorneys.
That works, right?
That works, that's right. In fact, speaking of work, you know, a number of you are familiar with some recent research that I, with a number of other folks, have been working on licensing and so on in biotech, and the question of access and whether that, how much of a problem that really is, whether there indeed is, how much of a full or empty box is the anti-commons and other issues. And what we learned is that, well, it's not that much of a problem, at least not the anti-commons per se, as opposed to the access to foundational upstream research, but largely by virtue of massive infringement, okay? And massive infringement not only among in universities, but where it's spoken of a little less openly, it's always in the form of, oh, and the other guys do it, is in firms as well. Massive infringement at that level, because detection, et cetera, for a lot of these things is often very hard. Is there anything wrong with that kind of solution to I mean, we have, these people invoke, they say, oh, there's the research exemption. We said, well, you might not really qualify. They don't
Right.
care, you know.
Right.
So they opportunistically invoke this informal research exemption, and life goes on, and research goes on, and that's not necessarily bad from a social welfare perspective, but I'd be pretty curious about hearing a countervailing view from attorneys, legal scholars, and others who might have.
Well, I guess I do have a slightly countervailing view.
No, that's fine. I'll keep the discussion among you.
Okay. The countervailing view I have is that, and I'm not necessarily sure that I disagree with you, but the argument on the other side would be that we basically have, you know, sort of a regime of pervasive law-breaking behavior essentially going on, and and you know, I mean, there are people who would argue, and you know, that there are all sorts of good reasons, like in a lot of another literature I'm familiar with, assisted suicide, that it's good to have laws on the books against assisted suicide, but it's also good to have pervasive breaking of those laws. I think in this situation it's a little more problematic, though, because the extent to which you can break the law really depends upon the particular research you're doing. And should we have, and the reason it does is because it depends upon how transparent your research use is. If your research use is not transparent, then you can break the law. And also, if your end product doesn't come out for a long time, then you can break the law, because there's a 6-year statute of limitations on these infringement claims that you can file. So, I mean, what are the consequences for, I mean, is that the way we want to set it up, that it's just serendipitous whether you can break the law or not, or should there be some more systematic framework? Because some of the areas where you can't break the law may be some of the areas where we really want you to be able to break the law.
So it's either create a profit center for attorneys or let this, I see. Okay.
Well, yeah, I mean, it's two bad options, and then the question is which is worse.
Right,
you know?
right.
Yeah.
No, precisely.
So, and no, I do think a research exception, unfortunately, will have to be a profit center for attorneys.
I wanted to try out something that I've been kind of picking up in this panel and some of the earlier discussions as well, and see what people who know a lot more about this than I do say about it. Is I've sort of gotten the sense of sort of two different ways of looking at patents. I mean, I heard both Arti and Bob talk about that there's a much clearer case to be made for the utility of patents in downstream therapeutics. They seem to be working in the way that the patent system was designed to work. And that in the upstream area, what seems to be happening is that patents are operating as these kind of, it could be like patent fetishism, or they're a marker in social discourse of you should take me seriously, I'm in the game. Whether that's the Terrys, I mean, you made the case, you made the case today, and Patrick made the case yesterday, that in order to be at the table, it was very, very helpful for you to have that patent. And I guess I missed it, but I guess Max Wallace was saying the same thing in terms of getting venture capital funds as a startup firm, that this was very important. Even though, a number of people have been saying, even though it increases the costs of research, arguably, in the long run. And yet, for the people who are like the Terrys or like the Max Wallaces, it makes sense to try to work the system in that way if patents are treated that way. So I guess my question is twofold. One is that right, that at the upstream level it's more a kind of social practice in which patents are being treated in a certain way? And if so, what, if anything, could be used to kind of reform that if it's actually not socially valuable? And do any of the reforms that you guys are promoting, would they actually get at that, at the kind of defetishization of patents?
I don't know. I actually have there's a very interesting article that you should read if you're interested in this issue by a professor at the University of Virginia by the name of Clarissa Long. It just came out in the University of Chicago Law Review on the economic term is patents, signaling through patents, like what the patents as signals. And yeah, and I do think that's absolutely right, that they serve a signaling function, that I'm a credible actor in this area. I'm not, I'm serious and I have a business model and so forth and so on. Again, I think that this is an area where law does have to step in, because I'm not sure that there would have to be some sort of collective action on the part of people who, the pharma people are the people who don't like these upstream patents for the most part. And the question is, what can they do to influence the behavior of biotech? Well, they can only do something to influence the behavior of biotech if they are, for example, owners of the biotech companies, in which case I think there would be collective action. These patents might go away. But short of that, I think we may need law in the form of various reforms that raise the patentability standard, essentially.
The other thing to observe, Elizabeth, you're right that that's actually how they're used when they actually happen. If you think about those 30,000 patents, probably 90 to 95% of them are not worth the 10,000 that they cost each to get. If you add it all up, you're talking $300 million that have been spent to get those patents, which is probably something on the order of 0.5% of what was spent on research over that same period of time. So it's not a huge tax on the system, but it is one. But the problem with trying to do these classifications post hoc is that you actually have to make the decisions when you're filing, and even actually before then. A lot of licensing happens before the patent even issues, and you actually don't know the value or even the functionality of the patent. So you file most of these patent applications before you know whether it's going to be useful or not. And so it's hard to, there are a lot of problems you can't solve just because of the uncertainties of what the value is eventually going to be, scientific value and commercial value. So a lot of the problems in the patent system are actually arising from that uncertainty, and these are just placeholders, people saying, okay, it's worth $10,000 to me to make sure that I can extract value down the road if I can, knowing full well that 90% of the time you're not going to be able to.
Unfortunately, we're going to have to cut the question and answer session there, although since I am standing behind the podium, I get to make one more comment. I just wanted to follow up on what Bob said, and I think in the gene patent area in particular, patent numbers can be very deceptive because it's patent scope that really matters. And indeed, you can look in a particular area and see hundreds of patents, and each one is not particularly a barrier to entry. It's perhaps an older or a lone patent off on its own that's quite broad in scope that can be the problem. So that's a very difficult thing to quantify, and I don't know if Bob has been able to do that. What time's the next session?
Okay. Wes will do that. Wes will do that.
Wes will get back to us next year and report on that. He will read through the 30,000 patents.
Oh, thank you, Wes.
Then hopefully he'll apply for a position with my law firm to continue doing that. What time is the next session, Lauren?
We're going to take a 10-minute break and start right on time at 11:15 because we have 4 panelists on our final panel and we want to hear all of them.
Thank you.